You know that feeling when you're trying to get your head around something complex and it feels like you're just wading through tons of information, but the clear picture, it stays just out of reach.
Yeah, like sorting through noise to find the signal.
Exactly. That's kind of what we want to do today. We're taking a deep dive into this alleged trade dispute. It involves the State Police Association, the EPA, and RBC Royal Bank.
And the core of it, right at the start, is this weird discrepancy.
Right. A claim of 42 officers involved. But the information we have suggests only 14 had actually, paid up for representation.
That's a big gap, more than double.
It really is. So our mission today basically is to figure out why. Why that difference, what might have been the motivation behind it, and how it all kind of unraveled in a surprising way.
And we've got some interesting stuff to work with: briefing docs, FAQs, quiz materials, even some personal theories jotted down. It gives a pretty rounded view.
Good. And we should probably mention the key players you'll hear about.
Right.
The EPA itself, RBC Royal Bank, Harrison Thompson, Robert Rumatar.
And especially a guy named Victor Sandy. He seems quite central to how things unfolded.
Okay, let's jump right in with those numbers then. 42 claimed initially.
But the documents point pretty clearly to just 14 who had paid for the EPA to represent them.
That's stark. So why? Why the difference? What's the thinking here based on the sources?
Well, the main theory that keeps popping up is strategy. Leverage.
Leverage? How so?
The idea, apparently, was that by saying 42 officers, the EPA could create this impression of a much bigger industrial crisis than maybe it really was.
Ah, okay. So it wasn't necessarily about 42 active documented grievances right then, but more about the appearance of a major problem.
Exactly that. It's about perception. Make RBC think they're facing a potential mass walkout or a huge legal battle.
Even if the actual number who'd committed financially was much smaller.
Right. It allegedly increases the pressure on the bank, makes them perhaps more willing to negotiate or offer a better settlement.
And one source, their personal take, just says it flat out, I think they inflated the number to negotiate with the bank. Pretty blunt.
Very blunt. It points to, manufacturing bargaining power they didn't really possess based on the paid-up members.
Trying to get a better deal privately, maybe, without it all becoming public?
That seems to be the alleged goal, yes. Negotiate a settlement or a buyout, keep it quiet, avoid the formal processes that might expose the actual lower number.
Okay, so that's the alleged strategy. But then something unexpected happens. The Ministry of Labor gets involved.
Yeah, and this seems to be the turning point. The ministry scheduled a conciliation hearing.
Now, is that unusual or just standard procedure?
It seems like standard procedure, but it was apparently triggered by inquiries. Specifically, those inquiries from Victor Sandy we mentioned earlier. He was asking why the dispute seemed inactive, why nothing was happening.
Okay, so Sandy's questions prompt the ministry to act. Why was this a problem for the EPA's supposed plan?
Because a formal conciliation hearing brings things out into the open, doesn't it? It moves it from a potential private negotiation into the formal, regulated system.
Right, where you need proper documentation. You need to show your cards, basically.
Exactly. Suddenly, that alleged strategy of using an inflated number in private talks is, well, it's at risk. The actual number of represented officers would likely have to be stated formally.
It forces transparency where maybe transparency wasn't wanted. Like that source said, the ministry workers setting a hearing date upset their private plan.
Precisely. The alleged quiet negotiation based on potentially a bluff was now facing public scrutiny.
So facing this conciliation hearing, what did the EPA do next, according to the material?
Well, around September 2nd, 2014, it looks like they re-registered the dispute.
Re-registered?
Yeah, with the ministry. But this time, they listed the correct number, 14 officers.
So a quick correction before the formal process really kicked off.
It seems that way.
Yeah.
The thinking, based on the FAQs and other docs, is that they likely did this to avoid having the initial higher number exposed during the official proceedings, a way to sort of clean things up before scrutiny.
And was this correction announced? Did they tell everyone involved?
The sources suggest no. It was done quietly, without necessarily informing all the officers who might have initially thought they were part of that larger group of 42.
Okay, so this whole sequence, the initial number, the alleged strategy, the ministry stepping in, the quiet correction, this leads to some really serious allegations, right? What the sources call a theory of the case.
Yeah, this is where it gets into potential legal territory. It's not just about numbers anymore.
What kind of allegations are we talking about?
Pretty serious ones. Things like fraudulent misrepresentation, knowingly stating false information, denial of natural justice, breach of fiduciary duty.
That means not acting in the best interests of the people you represent, right?
Exactly. And also, violations of constitutional fair hearing rights, and even an allegation of committing a fraud upon the industrial judicial process itself, basically undermining the legal system.
Wow. Those are heavy claims. And they stem partly from how that conciliation process started.
That's a big part of it. The argument is that the whole conciliation was flawed from the start because it might have been initiated based on that inflated number, therefore the certificate of unresolved dispute.
That's a document saying mediation failed, right? Allows it to go to court.
Yes. The argument is that certificate was issued under defective circumstances because the foundation, the conciliation, was potentially compromised.
And there's also a point about timing, isn't there? The delay in actually going to court.
Right. The retrenchment happened, then this conciliation business. But the case wasn't formally filed with the industrial court until around May 2015.
That's nearly a year later, almost 11 months after the retrenchment itself.
Yeah, and that delay is flagged in the materials as another potential issue, maybe a violation of procedural timelines or expectations.
Now, let's circle back to Victor Sandy. His name keeps coming up. How significant was his role in all this, really?
It seems pivotal. The sources consistently point to his inquiries at the Ministry of Labor about the case being stalled.
The ones that prompted the ministry to schedule the hearing.
Exactly those. His persistence seems to be what broke the logjam, or perhaps what disrupted the alleged quiet strategy.
So he wasn't directly involved in the EPA leadership or RBC, just an affected party asking questions?
Apparently so, and one of the quiz answers puts it very clearly. His actions disrupted the EPA's plan to avoid public scrutiny.
There's even a legal argument mentioned, isn't there? Something like, without him.
Yeah, but for Victor Sandy's timely intervention, the matter would have been procedurally buried without judicial resolution. That's a powerful claim.
Meaning the whole thing might have just fizzled out quietly if he hadn't pushed.
That's the suggestion. And the evidence cited is circumstantial but compelling. You have his documented inquiries, the fact the case was seemingly stalled or shelved, then the sudden hearing scheduled right after he asks, followed by the EPA quickly re-registering with the lower number.
It paints a picture of his actions forcing the issue into the formal public legal system.
It certainly looks that way based on the material we have. His intervention seems crucial to the case moving forward at all.
Okay, so let's try and pull this all together. We started with this alleged inflation of numbers 42 claimed, 14 apparently paid.
Which, the theory goes, was a strategic move. An attempt to gain leverage for private negotiations with RBC, creating a bigger sense of crisis than perhaps existed on paper.
But that alleged plan hit a snag when the Ministry of Labor, prompted by Victor Sandy's questions about delays, scheduled a standard conciliation hearing.
Right. That forced the issue towards formal proceedings, potentially exposing the number discrepancy.
Leading the EPA to, apparently, quietly re-register the dispute with the correct 14 names just before things got official.
And this whole chain of events sparked serious allegations. Misrepresentation, breach of duty, maybe even undermining the legal process itself.
With Victor Sandy's intervention highlighted as the key factor that prevented the issue from potentially being buried.
Yeah, the core takeaway seems to be this alleged use of inflated numbers for strategic gain, how that was unexpectedly disrupted, and the serious legal and ethical questions it all raises.
It really makes you think, doesn't it? Beyond this specific case, consider the implications. If numbers or facts can be allegedly manipulated like this in negotiations, what does that do to trust, to transparency?
Absolutely. And it highlights the importance of due process, of having those checks and balances like a ministry stepping in to ensure things are handled fairly, especially if there might be hidden agendas.
So maybe the final thought for you, the listener, is this. What other questions does this raise for you about how negotiations work, about the power dynamics, about ensuring fairness when the stakes are high and not everything is always up front? Something to chew on.